Laureate, symposiasts, ladies and gentlemen, it's a great pleasure to welcome you all to this Nils Klim Symposium in honor of the 2025 Nils Klim laureate Daniela Alaattinoğlu from the University of Turku, Finland. My name is Bjørn Enge Bertelsen. I'm the academic director of the Holberg Prize. The Holberg Board awards annually the Nils Klim Prize to outstanding young scholars from or working in the Nordic countries in the humanities, social sciences, law, and theology. We welcome all of you who are present here in the University Aula in Bergen today, as well as all of you watching online from around the world. For the Nils Klim seminar, the laureate is asked to both propose a topic as well as suggest the persons with whom she would like to converse. We look forward to taking part in the presentations and discussions during this year's Nils Klim seminar in honor of Daniela Alaattinoğlu. For her seminar, Daniela Alaattinoğlu has chosen a highly interesting and very relevant topic for today's world: Nordic rights development from the margins, reassessing legal inclusion and exclusion. To present the laureate and the symposium speakers, I hereby give the floor to Jørn Jacobsen, Professor of Law at the Faculty of Law here at the University of Bergen. He will be moderating the event. Please, Jørn, the floor is yours.
Dear all, welcome to this symposium where we'll honor this year's laureate, the Nils Klim Prize winner, Daniela Alaattinoğlu. And it's a great honor for me as a legal scholar to be able to welcome you to this discussion on the highly interesting topic that Bjørn was so kind to just introduce. This year's Nils Klim laureate, Daniela Alaattinoğlu, is an assistant professor at the University of Turku, where she currently is also principal investigator of the ESC project From the Margin to the Center, Right Development, Transitional Justice and Indigeneity in the Nordics. Daniela Alaattinoğlu has published extensively on a wide range of subjects relating to today's subject. She has addressed a lot of issues with a particular view of how law interacts with society and how societal processes come to shape law and give effect to human rights, for some at least. This was not least done in her very interesting thesis, Grievance Formation, Rights and Remedies, concerning involuntary sterilisation and castration in the Nordics in the period from the 1930s to the 2020s. So with this background, we are certainly going to dig into complex, interesting and important societal issues. And with that said, I give the word to Assistant Professor Daniela Alaattinoğlu. Please, the floor is yours.
Thank you very much. So, the Nordic countries, Norway, Sweden, Finland, Denmark, and Iceland, are often seen as progressive societies. These states frequently present themselves as global leaders in human development and as defenders of human rights. Yet, if we look more closely at the legal cultures of these nations, something quite striking appears. For a long time, rights were largely viewed not as binding legal tools, but as abstract ideals, guiding principles for public institutions rather than enforceable claims that individuals or groups could use to challenge laws or state practices. After all, the Nordic countries are places where parliamentary power has traditionally taken precedence, and where there's been a skepticism towards substantial judicial review. In the Nordics, lawyers have traditionally been imagined as professionals with technical knowledge of how the state machinery operates, rather than people who question the premises and functions of the state machine. At times, the phrase Nordic rights revolution is used to describe a visible shift, a growing role for law and rights in public life, and a more active use of legal tools by individuals and groups to contest policies and seek change. In an increasingly international legal environment, judicial review has become more accepted across the region and is now used more actively by civil society. This narrative of progress, of opening, has gained wide acceptance, but it also forms a key backdrop to much of my own work. But it is a narrative that tends to center elite legal actors, venues, and specific rights, such as the right to property. In this symposium, I would like to shift focus. I want to draw attention to 3 recent cases where people have used legal means to challenge systemic oppression as rights violations. What unites these examples is that they are rarely seen as central to Nordic legal development. More often, they are treated as isolated stories, telling us perhaps something about the groups involved, rather than offering insight about into the legal systems and the broader role of law in our societies. But what if we looked at them differently? What if, instead of treating these cases as marginal, we asked, what do they reveal about the nature and direction of Nordic rights development? The first lesson, I suggest, is this. Some issues have required extraordinary efforts, mobilization, campaigning, and legal advocacy, simply to be recognized as rights violations and their harms as rights issues and their harms as rights violations. The example I would like to begin with is the use of sterilization and castration policies targeting trans people. At birth, we are all assigned a legal gender, primarily based on the appearance of our genitals. Quite understandably, not everybody identifies with the gender assigned to them. Legal gender recognition, the possibility to amend one's official gender, has been introduced in several countries since the 1970s. Sweden was the first in 1972, but it came with preconditions, most notably a requirement of infertility. In other words, to legally amend their gender, trans people in Sweden had to be sterilized. The stated aim was to eliminate the risk of confusion in family relations and to ensure that a person registered as male does not become a mother, and one registered as female does not become a father. This model influenced many other countries. Infertility requirements were introduced with the assumption that all trans people wanted the same set of medical and surgical interventions, and that society's interest in a rigid gender order justified overriding trans people's reproductive rights. Often, these laws and practices were established without even consulting those most concerned, trans people themselves. Since the late 2000s, these policies have increasingly been challenged through strategic litigation, public campaigns, international advocacy, and grassroots mobilization. Still, in a world shaped by cis-normativity, or the assumption that people identify with the gender they were assigned at birth, it remains a major struggle to establish gender identity as a legal right. a right that cannot be made conditional on surgery, sterilization, or the removal of reproductive organs. A right whose violation requires acknowledgement and reparations. To this day, legal gender recognition based on self-identification remains contested in many places. Furthermore, few countries have followed Sweden's lead in offering compensation to those who were sterilized under earlier regulations, people who still live with the effects of these irreversible procedures. In the words of one of the litigants who unsuccessfully challenged the previous Norwegian policy before the courts, "The fact that I can't have children is something that will stay with me for the rest of my life." This example of sterilization practices and the long strategic efforts needed to contest them illustrates my first point, that some claims are more readily accepted as rights and some harms more easily recognized as rights violations than others. The second lesson I would like to highlight in the development of Nordic rights is this. Rights depend not only on their formal recognition, but also on who is entitled to hold them. In other words, rights holdership is deeply contextual. A striking example of this is the forced reproductive control of Greenlandic women. In recent years, Greenland, a self-governing territory within the Kingdom of Denmark, has been back in international headlines. These headlines remind us that colonialism is not just a remnant of the past. They also point to a practice that has only recently received the attention it demands: the systemic insertion of intrauterine contraceptive devices into the bodies of Greenlandic women and girls, most of whom are indigenous Inuit. Often, these procedures were carried out without the consent or even the knowledge of the women themselves or their parents. These widespread and state-sanctioned oppressive interventions were designed to limit the reproduction of Greenlandic women, mainly in the latter half of the 20th century, though reports of such practices continue to emerge. Today, the issue is under public investigation. So far, 143 women directly affected by these procedures have brought legal action, demanding reparations from the Danish state. Their claims point to long-lasting harms, fertility problems, chronic pain, and trauma. In the words of one survivor, "I was not allowed to rule over my own body or my uterus. I feel as if my body was colonized. Today, I have taken back my authority through my protests. I have decolonized my body, but I have no doubt that our bodies were colonized back then. It is only now that my body and my psyche no longer belong to the government." This case reveals a profound contradiction. While reproductive rights have on paper been strengthened across the Nordic region, especially through reforms in abortion and sterilization laws in the 1960s and 70s, which emphasized individual choice, gender equality, and bodily autonomy, these rights have not been experienced equally by all. What is often imagined as a universal framework has, in practice, come with exclusions. The principle of universality itself is tested when we see that some bodies, some lives, are treated as less worthy of rights protection than others. As one of the Greenlandic women stated, "It is only now that my body and my psyche no longer belongs to the government." That sentence alone forces us to question the integrity of the human rights narrative in the Nordic context. The example of forced reproductive control also shows us that public debate over who should reproduce and who should not is not just a dark chapter from the past. These conversations are still ongoing and their harms enduring, shaped by historical inequalities and current power structures. Therefore, the second lesson is this: our narratives of rights development in the Nordics must take much more seriously the question of who is granted the status of rights holder. And these exclusions, these exceptions to the supposed rule, need far more critical scrutiny than they often receive. The third lesson I would like to highlight is about justiciability, the extent to which rights can be meaningfully enforced through the courts. In the Nordic countries, courts have traditionally exercised restraint when it comes to judicial review. But this is not just a matter of institutional deference. It is also a question of which rights are seen as suitable for adjudication in the first place. Not all rights are treated equally. A clear example of this is the ongoing struggle over land rights for the Indigenous Sámi people in Norway, Sweden, and Finland. Reindeer herding, a traditional Sámi livelihood, has long been regulated by Nordic settler states within Sápmi, the Sámi people's ancestral territory. In Sweden, for instance, it is telling that the rights of reindeer herders were historically not recognized as rights at all, but as privileges. That legal status, granted at the discretion of the state, implied it could also be withdrawn at will. In recent decades, international legal developments and the Nordic states' growing engagement with supranational organizations have contributed, at least partly, to a formal de jure recognition of the Sámi as indigenous peoples. This recognition implies certain rights, including land rights. But this shift in formal status has not always translated into de facto changes on the ground. Land use in the Nordic countries remains highly contested, and the everyday realities for Sámi communities often remain unchanged. That said, Sámi organizations and litigants have increasingly turned to law, especially through strategic litigation and engagement with human rights bodies, to challenge these conditions. In doing so, they've contributed to a growing justiciability of indigenous land rights. Landmark legal victories, such as the Girjas case in Sweden or the Fosen case in Norway, have established important precedents. But the aftermath of these decisions raises another critical point. Even when rights violations are formally recognized, the remedies may be limited. This gap between legal recognition and material redress calls into question how the harms experienced by the Sámi people are understood, and how seriously those harms are taken in efforts to prevent them from recurring. In the words of the president of the Sámi parliament in Finland, speaking of recent decisions from the United Nations treaty bodies, I think these cases and the decisions really shed light to the very basic things that we've always known, that indigenous peoples have inherent rights. We've always had them. We will have them after the nation states fail, and we have to remember that we have to defend those rights, court by court and case by case, and show the world that these rights are real and that there are certain processes that need to be respected. So, the third lesson is this: the legal recognition of rights is not enough. When certain rights are pushed to the margins, sometimes dismissed as third-generation rights, they are often treated as less urgent and less enforceable. this hierarchy of rights is also visible in the Nordic context and limits the scope of meaningful rights development. So, what can we learn when we study Nordic rights development from the margins? Today, I have drawn on 3 examples to highlight elements of rights that deserve more sustained attention. Not just as the concerns of a few, but as core legal questions. The situated nature of rights and rights violations, the contextual dynamics of rights holdership, and the changing justiciability of rights. In all these examples, we see how law has been used to classify and govern groups, often with the state defining who belongs to that group and what that belonging entails. At the same time, we see how civil society actors have mobilized the law to contest exclusionary policies, to seek recognition and to demand justice. The cases that I have discussed also remind us that in practice, rights are often not as universal as we imagine. They are shaped by context, distributed unevenly, and subject to hierarchies, rather than truly inherent, indivisible, and non-discriminatory. While the Nordic countries may think of themselves as moral superpowers, as exceptional in our commitment to equality and justice, these challenges are, of course, not unique in our region. The questions of which issues are seen as legally relevant and whose experiences count as rights violations are fundamental everywhere. I would like to end this lecture by inviting the panel, composed of experts who have each, in their own way, expanded the boundaries of law, legal inquiry, and rights, to reflect on these themes. Here are some questions that I would like to pose. How can we better account for contextual and contested rights holdership? What role should legal scholars and practitioners play in recognizing and amplifying rights claims that emerge from outside traditional legal spaces? And how might interdisciplinary perspectives, especially from anthropology, the broader social sciences and humanities, help reframe what we consider a legal issue and who we see as legitimate legal actors? I look forward to your reflections. Thank you.
Thank you, Daniela, for introducing us to today's topic. And now I would like to invite the next speaker to the floor. Professor Reetta Toivanen is a professor of sustainability science at Helsinki University Institute of Sustainability Science. She has a specialization in indigenous sustainabilities and is currently Vice Director of the Center of Excellence in Law, Identity, and the European Narrative. Here she is working on issues relating to, in particular, migration and the narratives of Europe as an area of freedom, security, and justice, funded by the Academy of Finland. Toivanen is also Richard von Weizsäcker's Fellow at the Robert Bosch Academy. Professor Toivanen, the floor is yours.
So good afternoon, and let me start with thanking for the excellent organization of this event, and thank you so much for including me, and big congratulations to Daniela, and it's a real pleasure to be here, and I also think that this topic is really interesting to start with. So Daniela's Nils Klim lecture invites us to read Nordic rights developments from the margins by asking why some claims like forced sterilisation of trans people, involuntary IUDs in Greenland or Sámi land rights have been fought for decades to get this to be even registered as wrongs, and then even longer to be kind of registered and defined as legal wrongs. And I think this is a very interesting work that you have been doing. And I want to comment it from my own perspective. I'm an anthropologist, so I think my perspective is a little bit of shift of what you are looking at. But I come to the same puzzle, I would say, namely more thinking that how law makes its own subjects and how that impacts the Nordic legal developments, especially in the area of minority and human rights. In Finland, I have especially followed the rights development of Sámi people and also Roma. And I think my examples will come a lot from that perspective. My kind of Sámi and Roma collaborators have very often pointed out the problem in Finland that the very same instruments that are supposed to help to emancipate and support their rights claims are also forcing them to kind of adopt certain kind of identities or certain kind of self-understandings that are very foreign to them. And so kind of my point will be here to delve into the unsettling proposition that law not only protects people, it also kind of co-produces them. In other words, legal systems are kind of social technologies that at the same time empower and make up the minorities they seek to govern. And I think that this is very visible not only in Finland, but it's a very general tendency that we can maybe discuss later on. So we can picture law as a Janus-faced figure, like a dual nature of law. On the one side, it's a shield of empowerment, strategic litigation, like in the case of Girjas and Fosen, finally obliged Swedish and Norwegian courts to recognize Sámi reindeer herders as land rights holders. On the other side, it can be a trap. The same Nordic statuses long treated reindeer herding as just as another business, competing land use business in many Swedish litigation cases, for example. And at the same time, the sterilization was depicted as just a formal precondition for trans people who wish to correct their legal gender. So kind of normalizing the very violations that were carried out. The question then is not merely how people use law, but also how law uses people, how its categories seep into everyday common sense, shaping who may speak, what counts as a harm, and which futures appear imaginable. To unpack this people-making power, I follow Daniela's 3 lessons and pair each of these with anthropological evidence, surprisingly from Finland. So the lesson 1 was about recognition never being automatic. So Daniela's first case concerns the sterilization requirement that shadowed Swedish trans legislation for decades, and not only Swedish, as he pointed out. Contesting that policy required years of coalition building before courts or politicians would even discuss this bodily autonomy as a right. A similar dynamic, I will say, plays, for example, in the Finnish school system with Roma children. When a teacher has Roma kids in their class, they get a kind of booklet, a well-meaning booklet that is to teach the teacher about cultural sensitivity towards Roma children, so how to treat Roma families. The booklet is a very stereotyping booklet about Roma time management, Roma taboos, Roma gender roles. But then at the end of the booklet, it reassures the teacher that not all Roma kids are bound by their culture. The document's very genre performs a minor miracle. It turns the structural barriers, namely segregated housing, poverty, low teacher expectation, into ethnographic curiosity that belong to Roma culture itself. Harm disappears here behind the veil of difference. This is what Stephen Lukes has in his book on radical power called the third dimension of power. The power to set the agenda before any disagreement is even voiced, before anything is even discussed, before any claims have been even thought in, imagined. So when trans people or Roma parents finally mobilize, they must first wage an epistemic battle to have their suffering seen as a right recognized by law. As we heard this morning, also Professor Spivak's analysis of epistemic violence is also very useful here. When the dominant systems define what can be said and by whom, harm is done not only through exclusion, but through the shaping of meaning itself. Even when minority voices are included, they may be reshaped into scripted forms that only match the dominant expectations. So the takeaway here is legal struggles begin well before courts. They start in the silent labor of framing what counts as a rights issue. Daniela's second lesson asks who qualifies as the bearer of rights. The ongoing inquiry in involuntary IUDs implanted in Inuit girls and women in Greenland reminds us that the reproductive autonomy declared universal in Nordic statuses was and has been and still is very selective. I would claim that in Finland, the same kind of doubleness appears in the minority rights architecture. While Sámi people are granted difference-based rights, cultural autonomy, language rights, potentially some land rights, not very willingly, but anyway, because they are framed as different, as indigenous. The Roma, by contrast, receive primarily sameness-based rights, and on the Protection of Non-Discrimination Act, because they are thought not to be kind of different and worth of some specific recognition, but merely the point is that the integration has not been successful enough. So they need more kind of assimilative measures to help them. This hierarchy is built into the design. One group may ask for special measures, the other is told to rely on equal treatment. Yet even special regimes can constrict. The cultural autonomy of Sámi extends only to language and culture. Decisions on mining, forestry, and recently on wind farms remain with the state, despite the repeated calls to ratify the ILO 169, the ILO Convention on Indigenous Rights. As Sámi parliamentarians complain, self-government is, I'm quoting, is restricted to the distribution of certain appropriations, not to genuine control over livelihoods. Meanwhile, Roma interest must be translated into register legible to majority Finns before they receive any airtime in ministries or media. In short, rights holdership is not a stable label. It is negotiated through institutional filters that dole out legitimacy in graded doses. Professor Spivak might suggest that this need to constantly translate one's claims into majority-friendly language is a form of representational constraint, where the subaltern can speak only if they adopt the language of power. The takeaway: categories of indigenous, minority, even citizen are not mere descriptions, they are allocations of political voice and remedy. Daniela's third lesson highlights the Nordic ambivalences towards judicial review. Even after Sámi victories in Kirjas and Fusen, remedies were narrow and implementation has been extremely slow. I think that there are a lot of similarities in all of the Nordic countries, and in Finland I think that, for example, when we adopted finally the Non-Discrimination Act in 2004, The police recorded 47 hate crimes, whereas in the same year, the ombudsman processed more than 700 complaints. So this kind of shows that litigation remains rare, partly because there is a consensus culture. So if you want to go to the court, you are seen as a problematic figure, and you are kind of unfinished because you are looking for trouble. So going to court is looking for trouble. Moreover, when Sámi activists turn to the UN treaty bodies, as Daniela mentioned, and do that much more nowadays than before, but actually have a long tradition of using UN treaty bodies, the Finnish state routinely answers that these land disputes are so complex and complicated that by no means would UN understand, and the other monitoring bodies, they don't understand Finland's specific role in forest industry, and so on. And then in the end, promises that a domestic solution is on a way and it will be coming soon. And this kind of promise has been repeated for decades. So the takeaway is that courts can name violations, yet without political will and administrative capacity, recognition floats above ground reality. This reminds us that representation can never be neutral. Law may acknowledge harm while reproducing the very system that caused it. So I want to kind of copycat our president, Alexander Stubb, who always has like 3 points. So I have 3 points here to end with. I don't know why it just came. So bringing these strands together and sketch 3 mechanisms through which law fashions the subject it governs. One is this classification. Nordic legislation casts Sámi land use as traditional livelihoods and Roma practices as harmful culture. And each label leads to distinct governance tracks, special rights for one and integrationist measures for the other. Secondly, habituation through school curricula, media, and all kind of societal processes, minorities partly internalize majority expectations before any dispute arises. This is kind of alluding to Bourdieu's habitus dispositions manufactured by everyday legal encounters. And then the third, legitimation cycles. Once minority actors adopt this authorized idiom, human rights, jargon, cost benefits spreadsheets, they gain entry to the committees, but only after adjusting their claims to fit the hegemonic templates. The translation enables visibility even as it reproduces the same dependency. So in this sense, law is a mirror as much as a shield. It reflects back to minorities a state-sanctioned image of who they are allowed to be. As I still have 1 minute, I wanted to also propose something positive, like what could we do to get from this trap. And I think that one is this interdisciplinary diagnostics that Daniela is also in her work proposing. So kind of combining the black letter analysis with ethnography to uncover silent exclusions before they erupt into litigation. The participatory rights mapping with youth, with reindeer herders, with Roma parents can surface harms invisible to the doctrinal tools. The other would be the redistribution of agenda-setting powers so that consultations would not take part at the end of any processes, as very often with Sámi people has been happening, but really to give veto powers to the minorities participating in thinking about their own rights, backgrounds, and what kind of claims they would truly need, what kind of rights they would truly need. And then this temporal attention that I think is really, really important and kind of heartbreaking, that when we talk about reparations, that we should not talk about money now, but to understand that these traumas travel across generations, so that memory, trauma, and future autonomy should be all discussed in a kind of big picture and not just as individual cases. So I see my time is ending, so I hope that my speech is not about cynicism, but more about that, let's go to the future with new ideas and fresh thoughts. And congratulations again, Daniela, and I'm really excited to be part of this discussion. Thank you.
Thank you, Reetta, for sharing your knowledge with us. The next speaker is Vibeke Strand, professor at the Faculty of Law, University of Oslo, where she has also served as Dean of Research. Professor Strand has worked on a number of issues, mainly in the field of discrimination law and international human rights. She did, in this field, her PhD studies relating to discrimination in the context of religious practice. Currently, she's working on similar subjects, but now in the area of new technology and discrimination. So, Professor Strand, the floor is yours. Welcome.
Thank you so much. The title of my presentation is Non-Discrimination on Inclusion and Exclusion. And I would like to express my gratitude for the opportunity to participate in the Nils Klim Symposium and to reflect on issues related to those presented by the prize winner Daniela Alaattinoğlu. How marginalized groups use rights as paths toward possible recognition and reparation, and how this has played out differently across the Nordics, provides valuable contextual insights when we try to understand rights development. In my presentation, I would like to integrate the principle of non-discrimination into our discussion, and I will draw on examples from Norway. The prohibition against discrimination is a legal tool that aims for formal and substantive equality for groups that face disadvantage in various areas of society. In Norway, the protection against discrimination originated from protection against sex discrimination. It was then expanded to include new groups such as ethnicity, religion, disability, and sexual orientation. The prohibition against discrimination is a potential pathway for the marginalized, as it prohibits group-based differential treatment that does not have sufficient justification. Broadly speaking, the legal field of equality and non-discrimination law offers insight into how the principle of equality has developed over time, the interrelatedness between domestic law and human rights law, and the power relations between the domestic legislature and national and international supervisory bodies and courts. Furthermore, the supervisory mandates of treaty bodies established under UN human rights conventions, such as the CEDAW Committee, established under the Convention on the Elimination of All Forms of Discrimination Against Women, include possibilities for interaction between the committees and national NGOs, human rights institutions, and ombudspersons, thus bringing civil society into the non-discrimination legal framing. In this presentation, I would like to draw attention to different approaches regarding which groups are protected against discrimination and how this is closely connected to issues of inclusion and exclusion. I have selected 3 topics: the scope for legal interpretation by courts, responses from the legislature, and finally, a constitutionalization of the principle of non-discrimination. So the first topic, the scope for legal interpretation by courts, is closely connected to how the prohibition against discrimination is formulated. Is the prohibition closed in the sense that it exhaustively lists the protected grounds? Or is it open-ended and therefore available for new discrimination grounds to be included? Most human rights conventions, such as the European Convention on Human Rights and the UN Convention on Civil and Political Rights, include open-ended prohibitions against discrimination, meaning that in addition to an additive listing of prohibited grounds, such as sex, race, color, language, religion, they include the formulation or other status. And this has, for instance, allowed the European Court of Human Rights and the UN Human Rights Committee to expand the prohibition against discrimination to include, for example, sexual orientation, gender identity, and transgender people. The CEDAW committee has also applied an approach that has enabled inclusion. The convention is women-specific as it concerns discrimination against women. Through an intersectional approach, the committee has expanded the circle of persons who are subjects of rights under the convention. In General Recommendation number 28, the committee stated that sex and gender is inextricably linked with other factors that affect women, such as race, ethnicity, religion or belief, health, status, age, class, caste, and sexual orientation and gender identity. And this includes transgender women. The committee has underscored that state parties are to legally recognize such intersecting forms of discrimination and their compounded negative impact on the women concerned and prohibit them. On this basis, we can acknowledge that courts and supervisory organs, through the flexible category and other status, and through an intersectional approach to sex and gender as discrimination categories, have expanded the protection against discrimination to new groups. So where does this leave the national legislature? I now turn to my second topic. The national legislature may also have an important role in developing inclusive protection against discrimination. In Norway, a proposal in 2009 sought to combine an additive listing of original discrimination grounds with an open-ended formulation in the Norwegian Equality and Anti-Discrimination Act. However, the government decided not to move forward with the proposal as it was considered to transfer too much power to define who should have protection against discrimination from the legislature to the courts. Nonetheless, in the same legal process, a new general act prohibiting discrimination based on sexual orientation, gender identity, and gender expression was adopted. The interpretive development under human rights instruments, where these groups had already been included in the protection against discrimination, was part of the legislature's reasoning for expanding the prohibition. Thus, development through interpretation on international level influenced the legislative process at domestic level and its outcome. And some years later, in 2017, care responsibilities was introduced as a separate discrimination ground in Norway. And this was not a response to developments under international human rights law, but rather a reflection of increased equality between women and men in Norway regarding who takes parental leave and who provides care. It was acknowledged that new societal developments where more men take parental leave and are caregivers created the need for strengthened protection against discrimination based on care responsibilities. These are examples of how the legislator has responded to various claims for inclusion. However, there are also groups that have not yet been included in the National Equality and Anti-Discrimination Act. If a person is discriminated against because of the person's dialect, the person's regional background, obesity, or social status, it falls outside the protection. In 2014, a safety mechanism was introduced into the Norwegian constitution. As part of constitutional reform, a provision on non-discrimination was adopted. And I will now turn to my third topic, which is the constitutionalization of the principle of non-discrimination. The provision in the Constitution is broad, stating that no human being must be subject to unfair or disproportionate differential treatment. So this is a general non-discrimination clause formulated as an individual right that can be invoked before courts. The closer relationship between the openness of the constitutional norm on the one hand and the closed nature of the prohibition against discrimination embedded in the Equality and Anti-Discrimination Act on the other leaves uncertainty about who will be responsible for further developing of the protection against discrimination in Norway. If courts take on an active role in interpreting the constitutional norm, they could take the lead at the expense of the legislature. So what has happened during the 10 years that have passed since the constitutional norm was adopted? I have analyzed court practice from the different levels of the judiciary here in Norway. And so far, there are signs that courts are willing to analyze the constitutional norm in cases involving new individuals and groups, even though the prohibition has not been decisive in any of them. One example is the 2018 Femund Sitje case from the Supreme Court, where reindeer herders claimed that the law treated them differently than owners of other grazing animals, and that they therefore were discriminated against. And this case demonstrates the relevance of the constitutional norm in the face of potentially discriminatory laws. However, there are some perhaps more surprising examples of new groups that have invoked the constitutional norm. One example is Norwegians with cabins in Sweden, who argued that quarantine requirements during the COVID-19 pandemic, who treated them differently from Norwegians with cabins in Norway, amounted to discrimination. Another example involves one category of residence owners claiming to be discriminated against because they were treated differently from another category of residence owners. What is worrying, however, is that there seems to be a risk that the constitutional prohibition against discrimination may not receive sufficient attention from courts in cases involving original grounds for discrimination, such as sex and gender. In such cases, there is a tendency for courts to assert that separate assessments based on the constitutional provision are unnecessary, instead referring to existing equality and anti-discrimination legislation. So this means that there is a risk that the normative strength of the constitutional norm will not be fully acknowledged. Thus, constitutionalizing the principle of equality may have the unfortunate side effect of producing new hierarchies between groups. Let me conclude where I began. When we discuss rights, inclusion, and exclusion, I believe that the dynamics of the prohibition against discrimination, as it is formulated and interpreted at the intersection of domestic and international law, as well as across different institutions, should be integrated. And we also need to integrate the prohibition's potential role for rights enhancement. Thank you for your attention.
Thank you, Vibeke, for your thoughts. It is time for me to introduce the final speaker today. Professor Maja Unnithan is a social and medical anthropologist working on subjects relating to global health, international development, and human rights. Professor Unnithan's particular research interests are reproductive freedom, gender, and bodily autonomy. She is currently head of the Department of Anthropology at Sussex University and also director of the Center for Cultures of Reproduction, Technologies and Health since 2014. Professor Unnithan, the floor is yours.
Hi, everyone. Thank you so much for your invitation and for giving me the opportunity to share my reflections on the topic of Daniela's important work. I'll do so from the perspective of my own work on the meaning of reproductive rights in India. So I'm taking you to a different context outside the Nordics, among different communities, NGOs, and legal activists. So a human rights-based approach provides a significant framework with which to conceptualize and advance change in systems where gender inequality and injustice permeate. However, insights from on-the-ground, people-centered engagement with legal processes and rights suggest that such a framework is not sufficient for enabling social transformation. So what is required is then a consideration of the different ways in which power works and rights and justice are framed, evoked, embodied, practiced, and made meaningful in the context in which such universal law operates, as we've heard with the other speakers and Daniela's work. So how then can we better account for contextual and contested understandings of what Daniela calls rights holdership? That is, the entitlement to hold rights itself. And what kinds of conceptual framings can we mobilize to do so? But first, let us reflect on the topic and title of my talk, which is about the gap between rights and justice, and what this gap entails. What is that gap? Where is it? What does it look like? The idea that there might be a gap between rights and justice was forcefully brought home to me in 2010 when I was in Rajasthan in northwest India, sitting with members of SEVA, a legal aid organization, and we were discussing how effective the recent surge in rights legislation in India was in redressing reproductive rights for women. Many of SEVA's clients were poor women from lower but also from middle castes, who sought help in cases of domestic violence. But these were also women who complained to me and said, rights, adhikar, as the word is used in Hindi, rights have arrived, but justice, conceptualized as nyay, has not followed. So what did they mean by that? Rights had indeed arrived in India in a big way in the early 2000s through legislation. And this was especially symbolized by the Right to Information bill, which became law in 2005, and which very soon entered the lexicon of everyday talk on rights. Everybody was talking about rights. And RTI, as it was popularly referred to, was about people's legal rights, their adhikar in Hindi, to ask for information about their wages from their employers. But 2005 was also the year which saw the promulgation of the Protection of Women from Domestic Violence Act, or the PWDVA. Both the PWDV and the RTI Acts built on years of intensive social mobilization by civil society and legal advocacy groups, feminists, health and development activists. In the absence of any specific reproductive rights legislation till then, the PWDVA was the main legal mechanism used by legal advocacy groups on the ground in Rajasthan seeking to protect and promote women's rights, not just in terms of protection from sexual, physical, and mental harassment, but also to protect women from reproductive violence. Feminist lawyers such as Indira Jaisingh, Kavita Srivastav, who led the PUCL, People's Union for Civil Liberties, among others, argued that violence against women who were pregnant in the household constituted reproductive violence. So even though the law itself had no stated safeguard for reproductive rights per se, legal activists creatively extended the PWDVA to include the protection of reproductive rights. However, a key clause in this PWDVA was the protection of women's right to remain in their final residence, establishing their claim over property and access to their children. An important entitlement, given that women in these contexts often did not have any independent source of income or property, making it difficult to survive on their own, especially if evicted from their homes by their husband or final families. So why then did this PWDVA fall short of providing justice? The rights were there, but where was the justice, the nyaya that the women plaintiffs asked for? So women who came to claim redress against their husband and in-laws for their physical and mental abuse found that the law, although guaranteeing the right to residence, made no provision to help them gain economic independence, and in fact reinstated their dependence on their husbands. The right to residence, although hard-won, promoted their return to live with the very same people who perpetrated the violence, which felt like an injustice. So for the women seeking redress, the court's position was an injustice because it went against their own sense of what was morally right. Here, rights legislation can be seen then to be working against gender justice, because in that it reinforced the norms, expectations, and entitlements embedded in those hierarchical social relationships that for women have worked against their gender. So the idea then of justice is important because it portends a broader, more inclusive framework which goes beyond the legal domain to engage individuals and communities in a moral sense, thereby capturing, in Amartya Sen's words, a sense of wrongdoing or clearly remedial injustice which moves us. So primarily, reproductive justice then is a framework for power, explicitly defined by people like scholars like Ross, whom you know, as including both reproductive rights as well as reproductive health, but in a way that advances gender, social, and economic justice. That there is a disconnection between rights and justice is not a new idea. It finds resonance, for example, in the conceptual work of social scientists such as Wendy Brown and Zizek, who are highly critical of the moralizing, neo-colonial, and neoliberal tendencies implicit in international human rights frameworks. Their scholarship calls out for work which, for example, humanities people, social scientists, and anthropologists like myself have set out to do, which is to closely examine not only what rights and justice have come to mean in practice, but how they are combined discursively within specific contexts, as Daniela tells us, and bear upon reproductive and sexual subjectivities, subjecthood, what it means to be a person in that context, as well as sexual and reproductive health. What was evident from the subjective experiences of Rajasthani women who approached me and the legal aid organization, SEVA, was that while the PWDVA marked an important step towards achieving gender justice by declaring harmful certain domestic practices, the act was limited in its inability to address that structural gendered inequality and related precarities, both economic and social, that women faced in the domestic setting. By not addressing the broader structural inequities of gender, it became a narrow and siloed approach. But even more so, paradoxically, the PWDVA, that's the Protection for Women Against Domestic Violence Act, by forcing women to return to stay with their families, upheld the very patriarchal norms of familial arrangements, which made the practices of reproductive violation possible in the first place. So more broadly then, and I don't have time to elaborate, perhaps in the questions, this is further reinforced by the uncritical use of violence as a trope to gain reproductive rights for women, as people like Gayatri Spivak and Nivedita Menon, etc., suggest, where women, in a sense, become fixed in this category as an othered kind of being or person. A similar siloed approach was undertaken by a more national organization, Human Rights Law Network, in 2010, who drew on the right to life clause of the Constitution to argue for maternal mortality as a right to life violation. This was in the case Lakshmi Mandal versus Deen Dayal Hospital. Ruling on the death of 2 pregnant women, Shanti Devi and Jaitun, who were denied emergency obstetric care by a Delhi hospital, the Delhi High Court made a historic decision that preventable maternal mortality constituted a fundamental right whose violation constituted a human rights violation. Although hugely significant and landmark case, in which the right to life was expanded on to include reproductive rights per se were not foregrounded. And again, this goes back to your point, Daniela, about, what kinds of rights become important. And so I think that's a really key point. These examples also point to the fact that those seeking to promote reproductive rights, legal activists, the people who work in the field, even though they work creatively, even though they work on translations, even though they work closely with local activists, grassroots people, they work within the law, which is actually not set out to specifically address reproductive violations. So they are limited. So how then, and I come to the last bit of my talk, how then do we move forward to thinking about securing justice in reproductive futures? So in meetings with legal activists in India from 2017 onwards, I'm struck by the numbers of bills and petitions that have been through the courts involving gender and bodily rights. Petitions against forced sterilization, against child marriage, against triple talaq, which is against the annulment of marriage within Muslim personal law, against dowry and rape. Indeed, as the head of the HRLN, the Delhi-based National Legal Aid Foundation, said to me, and actually to a group of us, we have been experiencing a tsunami of rights regulation over the past 2 years. What did he mean by that? Now, central to this process of experiencing that kind of tsunami was the use of public interest litigations or pill petitions, where cases are presented on behalf of collective interess. This is a distinctive feature of the Indian Supreme Court's efforts to democratize access to the courts since the 1980s, actually, as Charles Epp discusses in his book on the Rights Revolution. So the HRLN organization used a pill petition in 2013 related to forced sterilization, which was brought up by a health activist, Devika Biswas, against Bihar state for carrying out unlawful sterilizations of 52 women. This was Devika Biswas versus Union of India and others, petition number 95. The sterilizations were carried out without any prior consent in unhygienic and unsafe conditions, where women were operated upon on school tables as opposed to in the hospital, under torchlight because electricity went out, and without running water or sanitary gloves. The Supreme Court then, in 2016, upheld the charges brought by Biswas and found the State Health Department in violation of women's reproductive rights, as well as the right to health. So HRLN lawyers then have played a major role in representing Biswas along with the support of health and human rights NGOs. And the significance of the Supreme Court ruling was that it made sterilization procedures carried out without consent by any state government as unlawful and specifically link the practice of sterilization to processes which meet human rights standards. It is precisely in this constant layering work of legal advocacy organizations through a succession of PILs, public interest litigations on sexual reproductive rights, that we can actually find an ideological and practical means of countering gender discrimination and ensuring reproductive justice. So this is slightly different from Spivak's saying that PILs and legal activism is okay, but we need, as Daniela has also mentioned, we need to go beyond this activism that just seeks representation in law to actually meet the justice side. Now, activists' use of rights and law as strategies to advance contested political goals has also been referred to as a form of lawfare. And according to Siri Glopin, sitting here, the concept of lawfare overlaps with legal mobilization in the sense that both refer to civil society actors using intentional strategies that engage rights or legal institutions as part of a broader socio-political struggle. But as she points out, not all forms of legal mobilization can constitute lawfare. Litigation only becomes lawfare if it forms part of a broader strategy, i.e., of an ongoing, contentious struggle between organized social interests for or against social transformation. So following Glopin, I would suggest that what is emerging in the context of an increasingly strategic and expansive sexual and reproductive rights work undertaken by legal aid organizations in India is actually a form of gender and justice-oriented lawfare. These mechanisms of lawfare will hopefully not just democratize access to the courts, but also make the attainment of justice more imaginable, where women are able to experience nyay milega, the receipt of justice. Thank you.
Thank you, Maya. Then it's time for me to invite the laureate and the other speakers to join me here in a conversation. And as they step on the floor, I think they deserve a well round of applause based on their talk so far. I think the natural place for us to start is by asking you, Daniela, in view of the many perspectives and viewpoints that have been brought up, do you have any comments to these talks, and did you get your answers replied to?
Yeah, thank you very much for all of your very thoughtful interventions. These as you've all heard, are very rich interventions, and I always find it quite difficult to immediately say something. I think I would probably need to think about it for some time, but I thought I will just maybe pick up on a few themes that I thought resonated across these presentations or across your speeches. So the first thought is really sort of a bit also, I think it was a thought also raised by you, that, you know, it's not just about how people are mobilizing and using the law, but actually what does law do to societies and people. And I think that was also in all of these. In all of your commentaries, I think that was sort of a cross-cutting theme, that the law always does something, or the law somehow transforms for better and for worse the people who claim it or the groups who claim it. And I think I think particularly as in, it was you, Reetta, who said also, talking about sort of epistemic violence, or referring to Spivak here, but also how that made me think of also how the law is an epistemic system, right? So it sort of chooses the kind of knowledge that it recognizes as legal knowledge. So it always entails some exclusion, and if we call that epistemic violence, I think was a very important point. Another point that I think resonated across all of these was the relationship between law and justice, and I think that's something that we all work with in one way or another. These kinds of problems also that emerge when people translate injustices that they experience as legal problems, and sort of that something is always left out, and again then that the law also tends to translate these injustices in ways that the law finds intelligible in that sense. Vibeke, in your presentation, I also really found it interesting that you brought up the constitutionalization and this creation of legal norms, and especially as important a legal instrument as the Constitution, and how that also entails creating a hierarchy of rights, and then particularly looking at the legal practice, how courts interpret that constitutional norm, and then especially if there are other non-discriminatory norms in the legal system as statutory norms, what kind of a hierarchy is created there. So I thought that was also very another interesting perspective that again brings us back to the topic that hierarchies are always kind of inherent in the law and how the law works, again, for better and for worse. I also wanted to come back to the point on that you, Maija, brought up on in your very rich account of this lawfare, and how civil society organizations are using law and are using rights. And it made me think of how there was, I think there was maybe 10 years ago, there was maybe more, or let's say some time ago, there was maybe more optimism also around how sort of rights are used and rights language, and there was maybe a tendency to, rather than talking about reproductive health, move to talking about reproductive rights, and then how there is now becoming more sort of dominant to talk about reproductive justice also, and that there is also an awareness, growing awareness of, again, the relationship between law and justice, and that if we talk about law and rights as legal instruments, that some concerns are always left out, and that talking about reproductive justice rather than reproductive rights might then entail that, and might encompass maybe, or be more inclusive of a broader broader concerns related to reproductive injustices, more or less. So these are just some thoughts that I have on the top of my head, but I really enjoyed listening to all of your very thoughtful presentations and commentaries. Thank you.
Well, one of the issues that sort of Daniela brought up was this particular so-called Nordic exceptionalism, or this particular view that we Nordics have on Nordic law and Nordic justice as sort of particularly good in a way. How would you view that?
That's a tough question.
Yes.
But I guess, I mean, the way I would sort of rephrase it a little bit and in a way that I can answer the question, which is, I think what is really striking about that, has come through in what I heard today, was how, gender equality seems to be really central to the way legal reform it takes place, and how while doing that, you might still then, as you were talking, Vibeke, about how the caring, the framework that is now being discussed here in Norway, it comes from that idea of gender equality, not so much in terms of, I think you were saying, rather than women's rights per se. So in fact, it's not actually women necessarily who are gaining from that, because of course gender is about men and women and people who are in between as well. So I think to me that seems to be an amazing way of taking things forward, but at the same time it's limited as well, which has struck me. I don't know if that answers your question in some way.
Vibeke, would you like to pick up on that, or?
Well, I can give some reflections from the Norwegian perspective. I think that in recent years it's been more and more important sort of to emphasize that equality is not only about women's rights but also men. And with regard to care, this is where we see like new problems arise, because when fathers are on paternity leave, suddenly they face many of the same forms of discriminatory treatment as women have used to experience for so long. And then we acknowledge that the legal protection wasn't clear enough, because they had to sort of argue that this was indirect gender discrimination, like a situation that was typical for women. They had to sort of go through the woman category. But then care obligations was sort of inserted. It was a much clearer argument for equality that was then put into the legislation. So there has been it's been a long development in Norway over 50 years or so. So I mean, it was women's rights wasn't in the legislation until 1978, and it was a big struggle to get that included. But the women's rights movement used law as a mechanism for change. So I guess that's maybe a Nordic approach. At least in Norway, it was successful. The first step was sort of arguing that the category general considerations, reelle hensyn, we say in Norwegian, that was used actively to promote women's rights, sort of to get that into the legal framing. And then we had separate legislation for women's rights after lots of debates. But it has moved from there, and today it's much more inclusive. It's not perfect, but it's also a discussion about what groups need protection, what is the difference between old power structures and inequality, and new situations that occur, like digital inequality. Should that be protected against discrimination? We haven't gone that far yet, but there are always new situations occurring, and seems to be a lot of them today. But care responsibilities, I'm not sure that, of any other country that has that explicitly in the equality.
And nor, so if I just very quickly say, and nor does that focus on gender equality outside the Nordic context. So talking about exceptionalism, I don't know if that's kind of, yeah. But because in India, the struggle has been for gender equality, actually.
Yeah.
That's the difference.
It's very interesting, and I really try to sort of resist the urge I have to drive this over in criminal law, so I'm sorry about that. So in order to stay focused on you seem to agree on a lot of things. You mainly nod to each other and sort of you seem all to sort of agree on your perspectives. Are there any sort of controversial points in the topics that you are discussing here? Do you think are there points of disagreements to locate here? What are sort of the most challenging points? Reetta, do you have
I might say something. I'm not saying that I would disagree. I mean, I think in this kind of friendly conversation, it's more about learning than thinking whether I agree or disagree with something. But I do think that it was really interesting to think when you started about the kind of expansion of rights, how the international kind of treaties have also influenced the way of how Norwegian courts have kind of also partly opened up to the other, how is it like the other groups. I was thinking about the EU anti-race directive and how that has kind of forced all the EU countries to adopt a non-discrimination legislation, also Finland. I think Germany was the longest time fighting against it, saying that we don't need it, but the EU was very strict and putting monetary sanctions, so you were forced to have a non-discrimination law, also kind of start with institutionalizing non-discrimination on the basis of also anti-racism. And that kind of, what I think is interesting, that also these international treaties, and now my example is this anti-race directive, that is also brought a discussion, very Anglo-Saxon discussion about what is race. That was very unfamiliar, at least in Germany, where I used to live that time, but also in Finnish language. I'm sure that's the same thing in Norway and Sweden, that this kind of understanding of race, as in the UK, activists had been discussing for decades. We came and we were like, we are not allowed to say that word, so it's not the vocabulary that we would use in any of our legal or even more societal language. So kind of interesting that what I try to say, and it's not the kind of critique, but I think it's a kind of a question that how much is it in legal education, for example, an issue to discuss that, this very important international developments that have also brought human rights to Norway, that there have been also kind of travelers, kind of conceptual, epistemic, violent travelers that have kind of also maybe influenced the way we kind of discuss diversity in another way that we might discuss otherwise. And this also leads to this very, very, I'm so sure I'm gonna quote you on this, rights have arrived, but justice has not followed. That if you work as an anthropologist, like I have worked with Sámi fishers and reindeer herders, so they speak a lot about things that are unjust, like not fair. But they don't translate it, by themselves to a legal language. You always need an NGO or some kind of person who will say that, yeah, but actually that constitutes a breach of this and that law. And, I can help you and bring that case further. But so what is the difference between the, this is unfair, it's not just, and then when it goes to the machinery of law, that it may, change it. Mm-hmm. That was just a comment. Mm.
Daniela, would you like to respond to that?
Yes, actually, maybe I'd like to backtrack a little bit, also connecting to what you said about Nordic exceptionalism and connecting also to sort of how these notions of equality and legal change has been brought about, particularly relating to gender equality in the Nordic region. I think there are also quite significant differences also between the Nordic countries in that sense, as in, for example, in Finland, I know that related to, for example, gender-based violence and related to many reforms relating to gender equality have sort of been have been established as a consequence of this kind of international and supranational pressure actually on Finland to enforce changes, even though Finland, at least today, likes to think of itself as a sort of a very progressive and gender equal country. So whilst in I think Norway and particularly also Sweden, that there has been maybe the opposite way of thinking, that the EU, for example, and the EU's notion of equality will bring with it some setbacks for gender equality in the country, in the national sphere, because for example, when it comes to for example, these cases of recruitment practices, there have been some cases also taken to the Court of Justice of the European Union that have also caused and stirred national debates, sort of who are the which understanding of gender equality should be the prevailing one, and sort of how is that national and supranational dialogue taking place. So I think that's a difference that we can clearly see within the Nordic region in that case. Then, yes, definitely. I also agree with Reetta that probably also influenced by transnational legal discussions, not just legal discussions, but discussions. There are also these kinds of concepts imported, or concepts that have influenced also the legal sphere in the Nordic countries, such as the concept of race, and that are perhaps still quite maybe struggling to be really recognized within the region. I don't know if I have anything sort of more to say on that I agree, and that I think it's an important point.
Yeah. I was just saying, I think that's an absolutely interesting question about how, on the one hand, the law sort of essentializes and picks up, selects certain topics and shapes the subject of the discourse, and what is. So, but I want to go a little beyond that, because I think from India the law doesn't shape everything in the way it shapes things here. And that has to do with having plural kind of discourses around rights, for instance. What is happening here is you find, and this is really interesting, that you find certain kinds of essential strategizing, which is where people make use of the law to gain what, in some cases to gain justice. You see, there is a legal culture that is completely maybe bought into more this kind of universal law framework, and how it's important to use the law to gain rights, the legal aid organizations. But there are also indigenous traditions, particularly around sexual and reproductive rights, that are not affected at all, are not framed by that same discourse. So, for example, and I think this is where this sort of still hides under the surface. It's not, and this is where, for example, in terms of there are longer traditions of rights. You have sexual rights and these are gendered, where men have right to, for example, in the communities I worked, to sexual access and sexual entitlement, intercourse, etc., with women, whereas women don't have that, but they have reproductive rights, access to becoming to becoming pregnant, or they have the right to that, an entitlement to that. So there are very different ways in which local populations think about these kinds of rights, which have not at all kind of surfaced or come up. So I think there are, and I think we need to pay attention to those. We need to listen carefully to what people are saying when about what do rights actually mean, to them, and they're different. There's a different language as well. So I was talking about adhikar, which is the word for right in a legal sense in India, but a lot of people in the communities use the word haq, which is a different, a longer and also linked to more Islamic traditions. Haq, which is the way they talk about their rights. So there's also different language, and I think going back to what Gayatri was saying earlier today about how, language structures things, and it's important to have that. So there's that as well. Sorry. Coming on
Vibeke.
that.
Well, I just wanted to have a short comment when it comes to the race concept that you talked about, that came from the EU directive on establishing prohibition against race discrimination. And you also have then the UN Convention on discrimination based on race. But in Norway, there has been this debate about the concept of race, whether we should have it in the legislation or not. And we have chosen to use the concept ethnicity and not introduce race as a concept in the discrimination legislation. And that has been criticized from the committee supervising the UN Convention on racial discrimination. But that's due to these very difficult historical understandings connected to the concept of race. So I'm not sure if Sweden or Denmark or Finland has race, or maybe they do. No, they have ethnicity. Yeah, so behind the surface, and there is some resistance towards what the EU then has proposed when it comes to what concepts are used. But I also just wanted to share a reflection. I'm not sure if that's a good time or no. Okay, because I'm just thinking about that there are many ways that claims for rights can be shaped, and we can talk about rights not only in a legal sense, but I tend to do that as a lawyer, so you have to have me excused. But even in the legal setting, it seems to be sort of, Daniela, in your examples, the non-discrimination sort of pathway doesn't seem to have been that central, because the groups used other rights for their claims, or but they could maybe have used the non-discrimination path in addition. Or I'm not sure if you want to share any thoughts on that, or would that have just complicated things, or made it too many rights, we have to select something? Or
yeah, I think it's a good question, really, and I think it also again sheds light to this question that the law, in many ways, have many limitations, and I mean, when it comes to discrimination or non-discrimination law, I think a general problem, in general with reference to these groups, it also, I mean, in practice, it also comes down to, I think, sort of which lawyers were consulted, what kind of instruments they were more familiar with. Maybe it also comes down to these kind of practical concerns. But when it comes to discrimination law, I think one common problem is that the problem of the sort of comparator group, and that might be sometimes difficult to find. And sort of, again, this it brings up the questions of difference and sameness, and what is sort of a justified, what kind of different treatment can be justified, and especially if there is a difficulty of bringing up a comparator group. Well, in the case actually of trans people, that has been in some of the Norwegian cases, that has been actually one strategy that was unsuccessful because of the problem also of the comparator group, or the ombud found that there could be a comparator group, that cis people could be a comparator group, but then the courts thought otherwise. Which is, of course, very, very problematic in that sense. That's maybe one response to that question. I also wanted just to comment on your comment on this kind of different words for rights, and that they were using, for example, this hak, and I think that really, again, shows us that law is just one way of thinking or about rights, or rights can be legal instruments, but they're also sort of notions of sociocultural entitlements, and that is much broader. And as you say, that we really need, I agree with that we really need to be more receptive to this kind of richness in sociocultural entitlements, and maybe also how law influences those notions of sociocultural entitlements. So they are not, I think, even though they may be different and law may be limited in that sense, they are influencing each other, I would say. But yeah.
Could I also have another reflection on your reflection of my reflection? So I think that's really again fascinating what you're saying about law itself being that's what the legal cultures, not just law being different from sort of other traditions, but also law as it's practiced in different parts of the world also are different, culturally different in some ways, even though we're using universal law. So the fact that the public interest litigation means something very different perhaps in India. But the other question about, the influence of the law on these social cultural traditions, I think that is also, again, really important and complex. We have not yet sort of understood that enough. But one of the things, for example, in the Indian context of this Protection of Women Against Domestic Violence Act, is that remember, the law is, as we were saying, it individualizes the woman as the claims holder, as the person who, and so now we can see why public interest litigation is important, because of course women have not taken that central role of becoming the individual claimant, but perhaps that is important in what the law is doing as well. That is, so it's not something that is negative. I think when we talk about sort of culture, we talk about, collectives and things like that. But sometimes when we are addressing this kind of really social hierarchic difference, where women really don't have those spaces or the power to claim things for themselves, that law that individualizes might actually be important in a sense to enable that, at the same time as it disqualifies or erases the more collective context of that tradition. So this is the kind of really complex, because haq is built on more collective notions of. So, and then when we're talking about reproductive rights, that's even more complex, because often the context of reproduction is very different. We haven't talked about abortion at all, but when we talk about reproductive rights, here you say, what does reproductive rights mean for you? It's about the right to abortion, to claim the. You go to India and you say, what do reproductive rights? It's the right to have a child, because so reproduction becomes this more, woman's womb is more publicly owned in a context there, as here you think about, so we get to all these very complex issues about, how do we move across these, things about collectives and individuals, those binaries that we're trying to disrupt, the collective, the individual, the women, men, etc. Reproduction as being something public or private, when it's private, it has its own terrible issues because the state can't intervene into that space, and yet, this has been going on in the US, for instance. So, sorry, we can't go more into this, but there is all those things linked to, linked, which I think we should really, harness the power of humanities, social sciences, everyone to kind of smash disrupt these boundaries and think about these spaces in between that we can, that are so fertile, actually. So, sorry.
We're about to run out of time, but I think we should take time to any in the audience, Siri first, and then, okay, a lot of questions actually, so we'll try to keep it short, so we're...
So people can line up here. So thank you so much. This was incredibly interesting. I just had some reflections on this the Nordic exceptionalism. And I think it's often said that the Nordic countries are very high on material rights realization, and weak traditionally, at least until recently, on formal rights protection. And so that is one interesting issue, this difference, which links to what Maya is saying, and that might be why the equality argument sometimes is stronger. Because this reads to rights, material rights realization have been very important. And paradoxically, the strengthening of rights protection, formal rights protection and rights mobilization has happened at the same time as an increasing inequality in societies. That might be coincidental, but maybe not, because there is also a cultural issue there. I remember sort of many decades ago, I was sort of studying the constitution making in South Africa. And one of the quotes that I was very taken by was from one of the ANC lawyers saying, we have to be sure that the right to health does not become the right to sue your doctor. Yeah. And that is something that is really, really important. We have been thinking in the Nordic countries rights as the right to a system that covers everyone. That's the right to health, the right to education, it's the right to a system that's fair to everyone. And I'm just thinking, just a reflection, is that something that we're losing when rights become the individual right to state your claim individually? So just putting it out there. And I also think, and sort of linked, maybe not, but there is also, I mean, there is a very strong mobilization of rights against, or the right against rights. I mean, the anti-rights mobilization is very strong. It's strong, of course, in the US, but it's very strong in Europe. It's also stronger against rights and courts in India, different places. So, sort of, well, where does that leave the struggle from the margins? Because these are often the rights that are really targeted in this right against rights struggle. So I don't have any answers to this, but I just wanted to put it there.
We have two more, or three perhaps, so if all keeps their comments very short, then we'll have time for Daniela to wrap things up at the end here before.
Thank you. I'm Rachel Suda from CSS in Mexico City. I'm from Law Transform here. And thank you all for a wonderful panel. Yeah, I wanted to kind of come back to the questions that you're all raising about law as an epistemic system and law as epistemic violence, as well as a contested terrain for different forms of struggle, and ask if there's something very specific about the topics that you're talking about, reproductive violence and gender violence, because it seems to me that while we're comparing across different forms of using law strategically in multiple different ways by social movements, there's something very specifically individualizing and anthropocene, anthropocening, if that's a term, about this particular field. Right? That it focuses so much on the body, I mean, on debates across different legal traditions where US traditions of bodily autonomy have been so central. And, you know, reproductive justice for me, and I think, Rina, you were alluding to this too, is not just about the human. It can't just be about the human. And the thrust of so much of the debates are about the individual having rights as rights holders, but also the remedies are often very, very individualizing. So I just wonder if you would like to comment on that. Thank you.
And then we have two more short comments, hopefully, before.
Hi, that was a terrific panel. I have two specific questions for Maya. Given India's federal structure, and given the wide variations in both fertility choice and the demographic, how would you compare a state like Rajasthan, which you have explored in some detail, with the southern states, where you in fact have greater choice, more education, and in fact, much greater reproductive choices available. So how would you actually square the federal reality of India with a particular case from Rajasthan? Another quick question would be the equivalence of hukuk, haq, and adhikar. To what extent I feel that the entry of adhikar into common parlance is in fact a testimony to the importance of the right discourse in public imagination. So I don't think, I don't think the two are actually, they're not equivalent, but on the other hand, I think the fact that they're using adhikar, to me seems that they are receptive to the law. To which I want to add a caveat, given that in India now the RTI is under terrible attack and we have complete data freeze on what's happening, how do we in fact look at either rights or justice?
Please. Okay. No more? Okay. I think there was one question directed to Maya. You should first have a go at that, short, and then Daniela, you will have the final one.
Okay. Lakshmi, I think the last bit, especially about the politics in which even the law functions, and or it shouldn't actually be affected by the executive of the Indian state, by the politics that's happening, but it is the fact that it. So even the RTI, the right to information, has been frozen, but I think that then, I think given the fact that it was so deep in people's consciousness, the fact that it's not available anymore, the injustice of it is also getting deep in people's consciousness. And so, I mean, that's really all I can see on the RTI because of, yeah. But in, I agree with so India is a huge country. We have 33 states, and the state of Rajasthan, where I worked, had itself 64 million people, or actually even more than 64 million people, which is more than the UK, where I'm based. So there is tremendous variation, but particularly the variation that Lakshmi is pointing to is between the northern states and particular kind of ways in which gender entitlements, gender practices exist, and the southern states that have seemed to be much more developed in terms of, rights for women, and generally sort of development indicators, health being better, lower fertility rates, and things like that. So in that context, how can some of these lessons from Rajasthan apply elsewhere, I think is what Lakshmi was asking me. So there are two answers to that. One is that yes, it can apply because Rajasthan, and because of a particular kind of fermentation of feminist activists like Aruna Roy, etc., who were nationally connected, that the model of the RTI was adopted across India, so that's one thing. But when it comes to the work around, and the HRLN, which is Delhi-based, is also a national organization through the People's Union for Civil Liberties. So they are working in all states, in terms of getting women's rights. But in terms of the southern states, I can only now refer to, because I've not done very detailed ethnographic work there. I'll just give you an example of a PhD student from whom we learned lots, who did work in Telangana, and found that the question was, and this is related to reproductive health, the question was, what is the quality in the quality of healthcare that people experience in Telangana, given that there's low fertility rates, that people use healthcare services a lot, and that they seem to have better, better outcomes. But what Govind found was that actually all this disguised something else that was happening, and this comes back to the question of minorities and discrimination, and it had to do with Islamophobia, also linked to the broader sort of the politics. that there was tremendous discrimination and Islamophobia through healthcare workers within legal aid organizations, within, and there was no quality of healthcare they were denied, proper healthcare service. Because of course, Muslims are, not me saying this, breeding and, and we need to contain that with, so there's a whole sort of population control discourse that is connected with the reproductive rights thing that we have to also be aware of. And I have not brought in that broader, because I was making a specific argument. But you're absolutely right. But it exists in pockets everywhere. And even in the South is what I'm saying. We cannot say everybody in the South can, Sorry.
Thank you. So we're at the end. Daniela, would you like to wrap things up for us?
Yes, I can, and I would also, if you other panelists, if you feel like you want to say something, invite you to comment. I don't think I can answer. These are all excellent comments and questions. I don't think I can really answer them as such, but just to offer some thoughts. It is definitely true that we are going from sort of solidarity in the Nordic region from a more maybe legal systems and societies that were more based on notions of solidarity, not necessarily solidarity with all, but and also consensus-based societies into more sort of rights-based legal systems and rights-based societies. And I totally, definitely agree that is part of this also increasing neoliberal rights framework, which is becoming more predominant in the Nordic region. And of course, that is a double-edged sword. It provides some people with increasing possibilities to mobilize and maybe even have some success before courts, which they wouldn't have had previously. But of course, it also means that resources become more important. It might further inequality, and the rights are very much individualizing, anthropocentric, and there is also counter-mobilization. I'm not necessarily sure if the counter-mobilization is only a problem of a growing rights culture, though I think there are also other sort of powers at play there. But my point is not maybe that I am not really trying to say that rights-based governance or rights-based systems are the way to go, or that these strategies would necessarily bring more social justice per se. I think that I'm trying to look at, as our legal systems are becoming more rights-based, trying to find out also how do those rights and how do those legal systems change in practice and what is happening really. And I think we have limited information about that, and I think we need to understand more about rights in practice in order to also then think about strategies of how to move forward. But I also invite you to comment on this if you feel like you have any.
We're at the very end.
Okay.
It's time for me to return the word to Academic Director Professor Bjørn Inge Bertelsen. But before I do, thank you all for your contributions today, and congratulations again to Daniela as this year's Nils Klim Laureate.
Thank you so much. As Jørn pointed out, the time has sadly run out, but I think I'm not the only one who has received an impetus to rethink law, to rethink legalities, to rethink rights and forms of inclusion and exclusion. I'll even revisit my legal anthropological work after this discussion. So I've been very inspired, and I think I share that with the audience. I would like, of course, first and foremost, to thank the 2025 Nils Klim Prize Laureate, Daniela Alaattinoğlu. Thank you very much for having been here and presented your work and having let your work be discussed by the symposiasts. So thank you very much. I would also like to thank the seminar panelists, Vibeke, Reetta, Toivanen, and Maja Unnithan. And I'm sorry I'm mangling all the names, but I mean, this is how I pronounce it. Thank you all for your contributions. They were excellent, and I think you could have gone on to discuss these things for a long, long time. And I think, and I hope you will discuss them after you leave the stage as well. I would also like to thank Professor Jørn Jacobsen for having expertly and deftly moderated this seminar. This is something we knew he would do, since he is a former Nils Klim Prize laureate himself, having received the prize in 2011. So. Last but not least, I want to thank the audience who has joined us here in the University of Åla today, as well as those who have followed us online. Now, today's program here in the Åla is over, but please join us again tomorrow for two major events here. First, we have the masterclass with the PhD students at 10 o'clock sharp, and at 2 o'clock also sharp, the 2025 Holberg Prize laureate Gayatri Chakravorty-Spivak will give her Holberg lecture. Both events will take place here and will also be streamed, so welcome back then to all of you. Thank you.